My lords, I seek a weak accommodation, my lords, in this matter, my lords. Please, my lord.
Please. Claimant's appeal. On income and other aspects, my lord. Attendance charges. Case of injury. 100% disability had been taken, my lord. 100% disability had been taken. Considered by a tribunal. This income taken at 10,000. Accident is of the year 2015. Age of the claimant was 21 years. As per chat 8,000. But as per exhibit P11, she has completed shorthand typing course, my lord. And also she was pursuing her MCom. Please. Because she has completed her shorthand typing course that has been produced at exhibit P11. Only on the ground that no documents have been produced to consider income.
It's a qualification.
No, only submission is that it's shorthand typing. She would have any. One judgment of Honorable Apex Court wherein attendance charges for life had been considered because 100% disability was taken. Please, she is suffering from dementia.
Dementia.
Please.
Associated with the accident.
Please.
Oh.
Because she has suffered brain injuries. At paragraph 11 of the judgment, evidence, considering evidence, tribunal has considered 100%. Please, the evidence it has come, my lordship. Paragraph number 12 of the judge. Paragraph number 17. Please. Please. No, considering that 100% bedridden, PW2 is neurosurgeon.
Globally, some amount consider. Otherwise, another 2-3 years, argue.
But because she's completely bedridden, PW2 neurosurgeon was examined. He has said that she requires an attendant for life, and next friend mother had been examined. How long? That has not been. But since next friend, that is mother, has been examined.
30 lakhs already.
Please, but in the judgment which I am relying, Apex Court had considered that since one certain amount can be considered because 100%. Tribunal had considered 5,000 as attendance charges, my lordship. 5,000 may be considered. That was in the year 2000 accident. 5,000 per month. Please, paragraph number 8 of the judgment. Since 100% is in that also brains, she had suffered brain injuries.
Monthly 6,000.
My lords, the petitioner had claimed 30 lakhs of rupees before the tribunal, my lords. The tribunal awarded more than 30 lakhs, more than what was claimed. My lord, although the award amount was to some extent on the higher side, my lord, taking a compassionate attitude towards the claimant, your lordships, the insurance company deposited the money. But my lord, the greed has no limits, my lord. They have again come in appeal.
Paragraph number 17 onwards, the tribunal has considered injuries, my lordship.
Paragraph
17 onwards. Paragraph number 8 of the judgment. 8 of the Supreme Court judgment.
The tribunal judgment.
Tribunal has considered 1 lakh.
Huh?
No.
Then evidence is required. Consider dismiss. Some amount.
Also, future prospects was not 100% disability was taken.
You have said it about 100 times now.
No, future prospects was not considered.
Thumb rule.
Yes, my lords. future prospects, my lord, my submission is, my lords, the income assessed is 10,000 rupees, which is more than the chart income, your lordships. Chart income is 8,000 rupees. If your lordships are inclined to add future prospects, then, my lords, because no document whatsoever is produced to show the income, 8,000 may be considered and 40% may be added to that, my lord. That will be more than 10,000 rupees.
It is not your appeal, no?
It is not my appeal, but when, my lord, appeal is filed, your
20
lordships,
as on the date, 24 years. Uh,
my lords, the Honorable Supreme Court says, my lord, that it can be again reassessed. Only because future prospects were not added, we satisfied, my lord. Only because future prospects were not added, we satisfied.
Is to give just compensation.
To reduce then, he is saying, income.
as per the shorthand typing course, he was only 24 years as on the date of accident. Considering that 100% she has been disabled, my only submission is that future prospects may be considered. Also, she was a bachelor at the time of accident. And my lordship, towards conveyance charges and future medical expense, only 25,000 has been awarded.
Evidence is
As per evidence, it is considered that she was 100% disabled, physically disabled.
Disability and future medical expense, how it is correlated?
ಒಂದಕ್ಕೊಂದು ಸಂಬಂಧ ಇಲ್ಲ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆಂಡಿಚರ್ ಬೇರೆ.
Conveyancing charges 25,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
But she was admitted for 6 months, 50 more than 60 days.
When you go by axial, so it is not.
She has suffered only respect submission is that she has suffered injuries to the brain.
ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜ್ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟಾರೆ.
Mane,
Please, my lords.
what may be the percentage of future prospects? Age ಎಷ್ಟು?
24 years, 40%.
24 years.
40%.
ಅದು 40% ಥಂಬ್ ರೂಲ್ ಮಾಡ್ದಂಗೆ ಮಾಡಕ್ ಬರಲ್ಲ ನಾವು. ಹಾ ಮಾಡ್ದಂಗೆ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಥಂಬ್ ರೂಲ್ ಮಾಡಬೇಕು ಅಂತಿಲ್ಲ.
Consider income of 9,000 and 40% I like.
Please.
Please, my lords. Please, my lords.
Dispose.
Grateful.
I'm for the response.
I have produced the RTC extracts.
RTC extract. ಯಾರ್ದು? ಯಾರು RTC?
Husband.
On last occasion, your lordship has directed me to produce the
Goa, no?
Please, my lordship.
Goa.
No, my lordship. She is in
Dharwad.
Karwar now.
Karwar.
On the last occasion they were present. Somehow the mediation the counseling did not materialize. He was not.
ಕಮಿಷನರ್ಸ್ ಕೈಯಿಂದ ತೊಗೊಂಬರ್ಲಿಕ್ಕೆ ಐತಲ್ಲ ರಿಪೋರ್ಟ್ ತಂದು ಕೊಟ್ಟಾರ? ಕಾಪಿ ಶೇರ್ ಮಾಡಿದ್ರೆ ನೀವು ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದ್ದೀನಿ. According to my client, Deputy Commissioner came to his house and inquired
Enquired.
about 3 days back.
Report, I think, has not come from.
Just a second. Just a second. Regular sir. ಎಷ್ಟಿದೆ ಪ್ರಾಪರ್ಟಿ?
In his name, nothing is there. In his father's name, 6 guntas of land and a house is there.
Ancestral or the self
That
acquisition?
is ancestral. And in that, there are 5 sharers, his mother and 3 sisters. 5. Serial number 2. That serial number 2 property is not, his name, his father's name not appearing, but it is ancestral property, out of which 28 guntas were acquired by the government. And that amount also kept without dispersing because
ಎಲ್ಲಿಟ್ಟಾರನ್ನ?
with the Konkan Railway and KIDB,
ಎಲ್ಲಿದು?
that is there.
ಎಷ್ಟು?
That because he is not a party there. He not in his name, not in his father's name. His grandfather name appearing, and he is having 1 anna or 2 anna of land. And others, where they are, it is not at all there. So that kept pending.
ಎಷ್ಟು ಪ್ರಾಪರ್ಟಿ ಎಷ್ಟಿದು?
RS number 77.
70.
ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ, ಏನೇನು ಹೇಳಬೇಕು, ಎಷ್ಟು, ಯಾವ ಸರ್ವೆ ನಂಬರ್, ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್, ಇರಿಗೇಟೆಡ್, ನಾನ್ ಇರಿಗೇಟೆಡ್, ಡ್ರೈ, ರೇಬಲ್ ಹೇಳ್ಬೇಕಲ್ಲ.
Serial number 1, property number 19A. 6 gunta, it is in his father's name. Father expired.
6 guntras of what land?
Dry land.
Dry land.
Dry land. Father's name, father expired. There are 5 sharers in that. He is having 1/5 share.
ಅಪ್ರಾಕ್ಸಿಮೇಟ್ಲಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಏನಿದೆ ಈ ಪ್ರಾಪರ್ಟಿದು?
About 2 or 3 lakhs.
ಫರ್
His share.
ಒಂದು ಗುಂಟೆಗೆ. ನಂತರ ಇನ್ನೊಂದು ಸರ್ವೆ ನಂಬರ್ 77.
77, even though he is having the share, how much share and what extent, it is not known to him.
ಯಾರ ಹೆಸರಿಗೆ?
Because it is, his
Grandfather.
grandfather was one of the joint owner.
Grandfather was one of the joint
One of the
owners.
joint owner.
ಇದನ್ನು ಅಡಮೆಂಟ್ ಇವ್ ತನಕ ಹೋಯ್ತೀನಿ ನಮ್ಮನ್ನ.
His grandfather, in the second page, Shet Vaman Balakrishna.
ಮೇಡಮ್ ಏನ್ ಮಾಡ್ತೀರಿ?
Apartment, no. It is not in his name or in his, apartment illa.
ಇಲ್ಲ ಇಲ್ಲ.
Illa illa. There is no apartment or it is, there are false allegation. Ashte.
My lordship, the amount is not mentioned. 17 guntas has been acquired by Konkan Railway, 10 guntas by KIDP. So there must be some amount, liquid amount, which is deposited. Whatever is share, at least, because the deposit is since 2016, my lordship, the mutation entry. So there must be some amount.
ಎಲ್ಲಿದೆ ಅದು?
KIDP and Konkan Railway, we don't know what is the amount. If the DC assists, then
ದಿ ಡೆಪ್ಯೂಟಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ ಇಲ್ಲಿ ತಿಳ್ಕೊಂಡು. ಅದೇ by your order dated 4/9/2024, we had said as under. First off, in terms of said order, comma, the appellant husband has produced the record of RTC relating to certain properties which are held in joint. First off, he also submits, the counsel for the appellant submits that certain property that stood in the name of grandfather of his client, having been acquired by the railways and KIDP,
KIDP, my lordship.
comma, the compensation amount has been stacked. ಎಲ್ಲಿ ಇಟ್ಟರದ್ನ ರೆಫರೆನ್ಸ್ ಕೊಟ್ನಲ್ಲ?
No idea.
ಕಾಂಪನ್ಸೇಷನ್ ಅಮೌಂಟ್ ಎಲ್ಲಿದೆ?
No idea.
Has been kept in store, maybe because of rival claims, etc. First, next, in view of the above, the jurisdictional Tahsildar is directed to comply with the above order and also ascertain and state the amount of compensation put in store. First, that information would come handy for adjudging the list at hands. Call on 14, next per copy. If the Tahsildar, a registry to send a copy of this, if the Tahsildar does not comply with this direction, he may be personally summoned to appear before the court to offer explanation. First, registry to send a copy of this order to the Tahsildar Karwar Taluka. Karwar Taluk idya? Karwar Taluka. Immediately by speed post. First, a copy of the order shall be shared with the learned additional advocate general for needful action. Yes. Call on 14th.
My lord, I have filed wakalat of one officer, my lord. It is a railway matter.
Ah.
All officers are one department.
Okay.
So I have given a submission also, my lord.
Office objection having been explained is overruled. Yes.
Yes, ma'am. And another one is that, well, only one book I got, I'll submit another book also, ma'am. That is not available.
ಅದು ಯಾವ್ದದು?
ನಾಳೆ ನಿನ್ನ ಪಾಳಿ, it is.
ನಾಳೆ ಬುಸ್ನೂರು ಮಟ್ಟ ಅವ್ರದ್ದು.
Yes, it was
ಒಳ್ಳೆ
not
ಪುಸ್ತಕ ಅದು.
available, but Bharat book ನವರು ಇನ್ನೊಂದು 15 days ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ
ಕೊಡ್ತೀನಿ
ತರಿಸ್ತೀನಿ. I'll find. Another one I have filed.
ಇನ್ನೊಂದು ಯಾವ್ದು?
I have filed already. Kannada Chandavik is already given.
ಕನ್ನಡ ಚಂದ DS ಕರ್ಕಿ ಅವರು.
Yes, yes, yes.
Mr. Kanvi assures that he would procure one more copy of Nale Ninna Pali
Please.
and submit it to the Bar Association,
Yes, ma'am.
Bar Association library, in terms of order dated.
Library.
So, Bar Association library,
Library.
in terms of order dated signed. So, ಏನಿದು?
My lord.
ಅಂದ್ ಕೊಡಿ ನೋಡೋಣ. ಅದು
Yeah.
ಕೊಟ್ಮೇಲೆ ನೋಡೋಣಂತೆ.
Yes, please.
ನಾಳೆ ನಾಡ್ದು ಕೊಡ್ತೀರಾ?
Yes, ma'am. Today,
Next
if
week
it is
ಕರೆಯೋಣ?
available this week, I will file.
Call next week.
Please.
ಅಲ್ಲಿ ಹಂಗಾರೆ 2 weeks ಅನ್ಬಾರ್ದು. At the earliest ಅಂತ ಹೇಳ್ಬೇಕು ಮೇಲ್ಗಡೆ.
Please.
Okay. Dr. Rajshekar Kusnurwat was a professor, science and physics ಹೇಳ್ಕೊಡ್ತಿದ್ದ ECG. It was ಏನು ಧಾರಾವಾಹಿಯಾಗಿ ಬಂತು ತರಂಗದಲ್ಲಿ, ಮೋಸ್ಟ್ಲಿ ತರಂಗ ಅಥವಾ ಪ್ರಜಾಮತ ತರಂಗದಲ್ಲಿ. When I was student. Yes. ನಾವು ಹೇಳೋ ಪುಸ್ತಕ ನೀವು ಓದಬೇಕು. ನಾವು ಓದಿರ್ತೇವೆ, ಓದಿದಾಗ ಹೇಳ್ತೇವೆ ನಾವು.
That I am doing it. In fact, when I was preparing for civil service, I have read number of Kannada books. I am also interested in that. I do that one. Please.
ಹೌದು, ಕೊಡ್ಲೇಬೇಕು. ಅವ್ರಿಗೆ
Registry has placed the above in the ground of without standing and technical. For 2 weeks time granted.
Claimants appeal for announcement, my lords. I seek dispersion of notice to R1, my lords.
Appellant in the connected appeal.
There is a connected appeal by the.
Second set ಆಗ್ಬೇಕು ಸರ್ ನನ್ನ appeal ಅಲ್ಲಿ.
My lords, calculation has been made, my lords.
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಸೆಟ್ ಬೇಕಲ್ಲ.
There is challenging of quantum.
There is one English judgment which our apex court has discussed in SP Sampath Kumar versus Union of India, 87 Supreme Court, where bench comprised of 2 judges. One judge was not participating. On that ground, that judgment is set aside. Bench means 2 judges participating in the process. ಒಳ್ಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ಓದ್ಬೇಕು.
ಕೊಡ್ತೀನಿ ಸರ್. Quantum, only quantum, my lord. It may be disposed of, my lord, I will file, my lord, during the course of the day.
Here is a calculation, my lords. We made both the.
My lord, the personal deductions, my lord, 1/3 has been deducted. 1/4 has been deducted instead of 1/3. And also, my lord, the
1/4 deducted instead of 1/3.
interest, my lord, 9% has been awarded.
6 ಆಗಬೇಕು.
6%.
6% interest. Only these are the two. Income very high.
Income, my lords. I have
One
made-
more, my lord,
I have made in
I am,
calculation.
my lord, submit before this court. The PW1, my lord, wife herself has admitted that, my lord, the deceased was earning rupees 10,000. But as per chat, my lord, 11,750. See her.
Whichever is more.
Income or not, income ಮತ್ತೆ
Income, Income, my lords, 8,000 has been taken, 11,750 has to be taken, my lords. And the consortium, my lords, 50,000 has been awarded, my lords. There are three dependents, my lords.
120 ಆಗ್ತದಾ?
120, my lords. And funeral and loss of estate, my lords. And the 10% has been escalation, my lords.
Interim compensation 15,000 already deducted by the court. 15,000.
Ex gratia. Ex gratia and compensation are two different things.
Interim
Ex gratia
compensation.
is given by the state because of XYZ reasons. Your state under Article 12.
Interim compensation ante ಕೊಟ್ಟಿದ್ದಾರೆ.
Yeah, you may call it. You should have stipulated that. What you call is irrelevant. There is one famous judgment of our Supreme Court by Justice Chandrasekhara Iyer. I forgot the name of that judgment. The difference between ex gratia, compensation, damages, very beautifully explained. Justice Chandrasekhara Iyer, a great judge of Supreme Court. Yes.
Please, my lords.
Wife's appeal, my lord.
Kindly
Wife's
place
appeal,
time.
ex parte decree of divorce was granted by the family court. Matter was referred to mediation. Thereafter, my lord, it was referred to the, my lord, demands for psychiatrist. They have submitted a report. During the, my lord, the mediation at the demands, my lord, the husband has, my lord, assaulted the, my lord, the wife and
ಥೆರಪಿ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹೋಗಿದ್ರು. But in the meantime, my lord, the husband, my lord, went to the village of the, my lord, the wife and assaulted them. Therefore, a criminal case has been registered against the complaint. Therefore, they have submitted a report. It's an ex parte decree.
So bipolar mania nidu.
Yes.
Bipolar mania. Certain times he will be cool and other times he will be violent.
Both are. The husband is also an aggressive in nature.
Both
Are in aggressive nature. Therefore, matter was referred to. Now, the family court, my lord, has records call for.
Even therapy, continuous therapy.
Yes, continue. Instead of records, my lord. May I request, my lord, instead of records, because an ex parte decree, my lord, the family court has to comply with the, my lord, Order 5, Rule 19. When, my lord, it says that, my lord, the notice has been served to the wife. Wife did not
But
appear.
appeal maintain ಆಗ್ತದೆ, you can make
My
that
lord,
application and hold matter. PA Kulkarni.
I can file, my lord, both appeal or under Order 9, Rule 13 also.
Whichever option you
Yes,
want.
my lord, that's the Supreme Court. And the cruelty, my lord, the Supreme Court, my lord, has
Our choice ಕೇಳು. ಇವ್ರಿಗೆ
the
ಕೇಳ್ಬೇಕು.
Supreme Court, my lord, has considered, my lord, various American cases, Australian cases, my lord, in these cases. What is the cruelty, my lord,
Merits you are saying or you are seeking for remand?
my lord, remand for an opportunity should be given to the wife, my lord. She has not filed any objection. Ex parte decree came to be passed.
Time, my lord. I need-
We'll set aside decree and remand away. There you can fight the battle for another
Time
50
limit may
years.
be fixed also.
Huh?
Time limit may be fixed also. There's no problem.
Praise time, my lord, please. I praise time, my lord. Please.
ಯಾರಿದ್ದಾರೆ ಅವ್ರು ಹೇಳಿಲ್ವಾ? ಆಡದೇವರು ಹೇಳಿ.
ಇಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರು last time appear ಆಗಿದೆ.
Please take.
Today he said he is out of station, my lord.
Tomorrow, day after tomorrow, last.
After vacation.
My lords, with your permission, my lords, the last previous serial number 10, my lords, kindly send the LCR as early as possible.
LCR ಬೇಕಾ?
LCR, send the serial number 10, my lords. This, forthwithly send, my lords. LCR may be sent forthwithly.
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅದು ಅಂತ. ಅದಾಗೆ.
And amount in deposit may transmitted to.
Yes, yes, it will go. We have made it a standard pattern.
Seeing the order. 2 days order will come.
Please, my lords.
Please.
Please.
Lord, the compliance affidavit has been filed on 9/7/2024, my lord.
What was the mandate?
The learned single judge, my lord. The The complainants are the retired lecturers. They filed a writ petition before this honorable court for the revision of the pension in terms of the earlier writ petition, which are similarly situated.
Revision of pay.
Revision of pay and consequential pension, my lord, since they are already retired. Therefore, my lord, the learned single judge has directed to revise the pay in terms of the government order dated 15 to 1999. On 15 to 1999, my lord, and another direction is similarly situated because learned single judge has followed the directions of the earlier writ petition order. So two orders have been passed, my lord.
Compliance with
First,
this order
and
parity.
similarly parity.
Parity.
Please, that is an order as passed. On 15 to 1999, my lord, two government orders have been issued. The first government orders which is applicable, those who are working after 1/4/1998.
Cut-off date.
Cut-off date.
Cut-off date is.
Those who are retired before 31/3/1998, those who are retired before 31/3/1998, my lord, the government order 2, PET 2 order will be applicable.
Same date.
Same date 2 orders.
ಎರಡು ಆರ್ಡರ್ಸ್.
ಹೌದು ಸರ್. 31/3/1998ಕ್ಕೆ ಎರಡು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ ಗವರ್ಮೆಂಟ್ನವರು. PET 1 ಅಂತ ಒಂದು ಆರ್ಡರ್ that is applicable to those who are retired after 31/3/1998. PET 2 is applicable those who are retired before 31/3/1998.
ಇದೇ ಆರ್ಡರ್ ನಲ್ಲೇ ಇದೆಯಾ ಅದು?
Please.
Same 15 to 99 order itself speaks of both the classes or separate orders?
Two separate orders.
Separate orders.
Two separate.
ಆ ಯಾವ ಆರ್ಡರ್ ಅಂತ ಸ್ಪೆಸಿಫೈ ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲಿ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಹೇಳಿದ್ದಾರೆ PET 2 ಅಲ್ಲೇ ಮಾಡ್ರಿ ಅಂತ.
PET 2 ಅಂತ ಹೇಳಿದಾರ?
ಹೇಳಿದ್ದಾರೆ. PET ಅಂದ್ರೆ PET 2.
ಸ್ಪೆಷಲ್ 2 PET
2. ಹಾ ಕರೆಕ್ಟ್. ಹೌದು ಸರ್. ಇದ್ರ ಪ್ರಕಾರ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅದು ತೋರಿಸಿ.
ಪ್ಲೀಸ್.
ಇವ್ರು ಯಾವಾಗ ರಿಟೈರ್ ಆಗಿದ್ದು?
ಇವರು ಬಿಫೋರ್ 1998.
ಸೊ 31/3 PET 2 ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್?
PET 2 ಅಪ್ಲಿಕೇಬಲ್ ಆಗುತ್ತೆ.
PET 1 ಕೆಳಗಡೆ ಕಂಪ್ಲೈ ಮಾಡಿಕೊಂಡ್ರ?
ಇಲ್ಲ. PET 2 ಅಪ್ಲಿಕೇಬಲ್ ಆಗುತ್ತೆ. ಸಿಂಗಲ್ ಜಡ್ಜ್ is also directed to revise in terms of PET 2 only.
Because retirement is post 31/3/98.
Please.
ಆ ರೀತಿ ಮಾಡಿದ್ರ ನೀವು?
ಆ ಟೈಪ್ ಮಾಡಿದ್ವಿ ಸರ್.
Parity aspect ಏನ್ ಬರ್ತದೆ?
Please, that is an important question. For those who are claiming a parity was wrongly fixed under PET 1 earlier. So therefore, now the action has been taken because learned single judge has directed to follow the PET 2. And also there is a rider.
PET 2 follow ಮಾಡಿದ್ರೆ PET 1 ಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆನ್ಷನ್.
Please. PET 2 ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರು ಸಿಮಿಲರ್ಲಿ ಸಿಚುವೇಟೆಡ್ ಕೊಡೋಕೆ ಹೋದ್ನಪ್ಪ ಅವ್ರದ್ದು wrongly has given under PET 1. They are also the similarly situated people also entitled the pension under PET 1 only.
ಇವರು ಕೊಟ್ಟಿದ್ದು ಯಾವುದು?
Please.
ಬಟ್ PET 2 ದಲ್ಲಿ ಕೊಟ್ಟಿರಿ ನೀವು. PET 1 ದಲ್ಲೇ ಕೊಟ್ಟಿರಿ.
PET 1 ದಲ್ಲಿ wrongly fix ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಅವರಿಗೆ. So that is why, my lord, now the action has been, compliance has been taken. So in terms of the directions of learned single judge, my lord,
PET 2 ಕಂಪ್ಲೈ ಮಾಡಿರಿ ಈಗ.
PET 2 ಕಂಪ್ಲೈ ಮಾಡಿದ್ವಿ. ಅವ್ರಿಗೂ ಸಹಿತ ಸಿಮಿಲರ್ಲಿ ಸಿಚುವೇಟೆಡ್ ಪರ್ಸನ್ ಸಹಿತ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಏಜಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು we have filed that order.
Yes.
So, but we said there is no recovery because the wrongly amount which is given, we can't recover it, my lord. That in the keeping in the mind of that, my lord, we have said we are not going to recover the amount which is wrong.
ಎಷ್ಟು ವೇರಿಯೇಷನ್ ಎಷ್ಟಾಗ್ತದೆ
ಮಂತ್ಲಿ ಬಹಳ ಆಗುತ್ತೆ ಸರ್.
ಎಷ್ಟು?
ಅದು ಅಲ್ಲಿ PET 1 ಅಲ್ಲಿ ಮಿನಿಮಮ್ 10,000 ಬಂದ್ಬಿಡ್ತಾರೆ ಅವರು. ಇಲ್ಲಿ 3,499 ಗೆ ಬರ್ತಾರೆ.
ಲೆಸ್ ದೆನ್ 2.5 ಟೈಮ್ಸ್ ಆಗ್ತದೆ.
ಹೌದು. 3,450 ಮ್ಯಾಕ್ಸಿಮಮ್ ಬೆನಿಫಿಟ್ ಐತೆ ಅಲ್ಲಿ PET 2 ಅಲ್ಲಿ. ಅಲ್ಲಿ 10,000 ಇದೆ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ.
ಅಟ್ ಲೀಸ್ಟ್ ನೀವು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಏನಾರ ಕೇಳ್ಕೋ ಜಡ್ಜ್ ಹತ್ರ. ಹಿಂಗಿದ್ದಾಗ ನಾವೇನ್ ಮಾಡೋಣ? ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದ ಡಿಫಿಕಲ್ಟಿ. We understand the difficulty.
Now we have also taken a measure.
Others
also because wrongly given, the state has got all the power. If they wrongly given, we have power to rectify it. We have done it. We are going to do it. For that, the orders have been issued. And it is in the
ಎಷ್ಟು ಅಮೌಂಟ್ ರಿಕವರಿ ಮಾಡೋದು ಮಾಡಿದ್ರೆ ಎಷ್ಟಾಗ್ತಿತ್ತು? ಅಪ್ರಾಕ್ಸಿಮೇಟ್ ಯಾರ್ದಾರು ಒಬ್ರದ್ದು ಹೇಳಿ.
Around 15 to 18 lakhs.
ಕರೆಕ್ಟ್. ಇವರ ಎಂಟೈಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
That's the reason, my lord. They have gone, my lord, beyond and behind the order.
Correct.
Which is not permissible.
No, not like that.
What is not
ಅದು
dealt by the,
execution.
what is not dealt
ಅದು
by the.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ಡಿಗ್ರಿಗೆ ಅಪ್ಲೈ ಆಗ್ತದೆ ಈ
What is-
ಪ್ರಿನ್ಸಿಪಲ್ ರಿಟಿಗೆ
yes.
ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಂತ ಹೊರಡು ಮಾಡ್ಯಾರ.
My lord, what is not dealt by the writ court order, they can't raise it in the contempt proceedings as if it is a.
I will tell you, there is mongoose and cobra are put into one basket by this operative portion of the order.
Yes,
They say we have chosen
Yes.
mongoose.
they are going behind that, beyond that.
That question, that arises only in the law of execution.
Yes.
In law of contempt, your principle is alien.
Different.
ಹಂಗಾಗಿ ಬಿಹೈಂಡ್ ಹೋಗ್ಲಿಕ್ಕೂ ಬರ್ತದೆ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಈಗ. ಪ್ರಶ್ನೆ ಅದಲ್ಲ. Question is, how are you entitled to? You have retired after 31/3/98. You fit into PET 2. PET 2 ಕೇಳ್ಬೋದು ನೀವು.
I have produced, my lord, along with my, this annexure D, my lords, along with my application,
ತೋರಿಸಿ.
along with my annexure D, my lord, page 6, my lord.
You tell what you want to say. We have read the papers.
That's all. You'll kindly look to the, my lord, annexure, my lord, D, my lords.
Admittedly, they are paid more money. There is
No,
no dispute at
no.
all. Those people.
No,
Now they have passed an order.
no, no, that is not the, my lord, the part and parcel of the order at all. It is only corollary, my lord, that because as on the date of, my lord, the passing order, it had become final. It had become final.
ಬರ್ಕೊಳ್ಳಿ.
My lord, may I?
You have said how much it's a contempt matter compliance. It's a contempt matter. How much compliance is? 5 ನಿಮಿಷ
No,
ಕೊಡ್ತೀನಿ
no,
ಅಷ್ಟೇ.
no, 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 my case is different.
ಹಾ.
My case is different.
ಹೇಳಿ.
One second, ಈ ಕಡೆ.
ಹೇಳಿ ಹೇಳಿ.
Annexure D ತಾವು ದಯವಿಟ್ಟು ತಗೊಳ್ಳಿ.
ಎರಡು ಸರಿ ಓದೇ ನಾವು ಈಗ. ನೀವು ಹೇಳಿ ಏನು ಅಂತ.
Annexure D, my lord.
Yes.
The revision, my lord, is clause 2 of the annexure D. That is, my lord, 2 PET. That is the direction.
Correct.
May I read, my lord, the order?
I have read that order twice now.
ಇಲ್ಲ, ಒಂದ್ಸಲ
Simple
ಓದಿ.
order. Follow. No, you can't waste time that way. It's a public time. If you want to say something else, we'll record. Otherwise, we'll write only one line order. We have read wherever justice can be given, straightway we will give. They are saying you are entitled to PET 2. Though they had given PET 1 benefits to others who were similarly
ಇಲ್ಲ,
paralyzed.
that is the point. Willful disobedience, my lord, includes this such, my lord, frivolous reasoning. Look to their, my lord, additional statement of, the statement of objections, compliance of right. That is, there they have committed, my lord, contempt. Look, they say, they have produced annexure R2. They admit, my lord, that our basic pension is 8,750. How can they, my lord, they reduce it to 3,450 in the contempt proceedings and still claim, my lord, they have complied with the court order? Look to the annexure R2, my lords. It requires consideration, my lords. I am not standing on, my lord, the technicalities. My lord, I am also, my lord, aware of, my lord, what the learned friend says. The limited scope of contempt, yes. But if there is, my lord, the flagrant violation of the court order, disobedience, then it is for your lordships to come, my lord, deal with them.
Yes.
My lord, annexure, my lord, what I am submitting is, the order, my lord, is not one thing. It is not just a, my lord, there is no discretion left to the government. It is not a direction to consider our case.
Direction to pay.
Not only pay, revise pay and with arrears.
Correct.
And,
Pursuant
my
to
lord, and if not paid within 3 months,
interest.
carry interest. Admittedly, my lord, they are not complied with the court order within 3 months. So we become, yes.
Delay ಇದೆ. That is why, my lord, see, government will pass an order. That will be, AG will be accounted. In case if it, interest is not paid, my lord.
How long it will go on?
Well, it will be done, my lord.
Yes, please.
But, it will be done. This,
ಅದನ್ನಾರು ಕೊಡ್ಬೇಕಾ?
ಅಲ್ಲ, interest is, see, interest I bound to pay. as
ಏನು
per the-
ಕೊಡಂಗಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ.
ಅದೆಲ್ಲಿ ಕೊಟ್ಟಿರಿ?
ಅಲ್ಲ, the bylaw, just now.
Passing orders is not compliance.
Please.
Passing order is not compliance. Money should reach the pocket of the retired employee. Then it is compliance. ಆ ಪ್ರಕರಣ ಇಲ್ಲಿ P2 is true. Even if P2, 15 to 1999.
P2 ಆಗಿಲ್ಲ ಸಾಹೇಬ್ರೆ, ಅದನ್ನ
Still you have to make the payment.
Please.
ಆ ಪೇಮೆಂಟ್ ಮಾಡಿ.
Please.
Lord, P2, my lord, is not, my lord, clause 2, me kindly just have a look at it, my lord. Kindly, my lord, my lord, beg your pardon, my lord, to insist upon your lordship not to.
ಅಲ್ಲ, ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿ ಬೇಡ ಅಂತಲ್ಲ, ಅದಕ್ಕೆ ಇಟ್ಸ್ ಯುವರ್ ರೈಟ್ ಟು ಆರ್ಗ್ಯೂ.
My lord, it requires consideration, my lord. Clause 2 may kindly be seen of, my lord, the annexure D. First page itself, how the, my lord, the revision has to be made. What they have done is, my lord, arbitrary.
No.
What is, was not dealt with. They did not, my lord, raise this question in the writ proceedings. They have not filed appeal.
Correct.
Now they can't do it. No, lordship kindly, my lord,
That's right.
revise pension and family pension, page
Correct.
6.
ಶೆಟ್ರೆ, ಇದು ಕಂಟೆಂಪ್ಟ್ ಜುರಿಸ್ಟಿಕ್ಷನ್.
ಅದನ್ನೇ ಅಷ್ಟು ಲಿಮಿಟೆಡ್
ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ.
ಇಲ್ಲ, ಲಿಮಿಟೆಡ್ ಅದನ್ನೇ ತಮ್ಮ ತೋರಿಸ್ತಾ ಇದೀನಿ. ಏನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಏನ್ ಮಾಡಿಲ್ಲ ಅಂತ ತಮ್ಮ ತೋರಿಸ್ಬೇಕಲ್ಲ ನಾನು.
ಅಮೌಂಟ್ ಆ ಪ್ರಕಾರ ಇರೋದಾರೆ ಯಾವಾಗ ಕೊಡ್ತಾ ಇದೀರಿ? P2 ದರ ದುಡ್ಡು ಕೊಡ್ಬೇಕಾ?
ಅಲ್ಲಿ ಒಂದ್ ಸೆಕೆಂಡ್ ತಾವ್ ನೋಡ್ಬಿಡಿ ಅದನ್ನ, ಒಂದ್ ಸೆಕೆಂಡ್ ತಾವ್ ದಯವಿಟ್ಟು.
ಏನಿಲ್ಲ.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ತಾವು ದಯವಿಟ್ಟು annexure R1 ತೋರಿಸಿ. That is an order which we have passed.
ದುಡ್ಡು ಯಾವಾಗ ಮುಟ್ತದೆ?
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಈಗ R2 ಅಲ್ಲಿ that order has passed, it has to be executed by way of accountant general has to be calculated and he will pay, my lord.
ಯಾವಾಗ ಮಾಡ್ತೀವಿ?
ಅಲ್ಲಿ ತೋರಿಸ್ಬಿಡ್ಲಿ.
ಅಲ್ಲ
ಅದನ್ನ ಕೊಡಿ ಮೊದಲಿಗೆ, ಆಮೇಲೆ ನಾವು ತೋತೇವೆ.
in terms of the R2, my lord, but I will kindly pass over, my lord, when it will be, amount will be, whether I will, since the order has passed in the month of July, month of July will pass ಆಗಿರೋದ್ರಿಂದ whether it has already deposited or not, that I will clarify.
ಅಮೌಂಟ್ ಯಾವಾಗ ಹೋಗಿದೆ ಅಕೌಂಟ್?
ನಾನು ಮಾಡಿದ್ದೀನಿ ಅದನ್ನ.
ಈಗ ರಿಟೈರ್ಡ್ ಎಂಪ್ಲಾಯ್ ಬೇರೆ ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆಯೋದ್ರಿಂದ ಏನ್ ಜಸ್ಟಿಸ್ ಆಗೋದಿಲ್ಲ.
It has to be reached.
ಅಮೌಂಟ್ ಕ್ರೆಡಿಟ್ ಆಗ್ಬೇಕು.
ಆಗ್ಬೇಕು ಸರ್.
ಅವಾಗ ಮುಂದಿನ ಪ್ರಶ್ನೆ.
ಒಂದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಇದರಲ್ಲಿ, ಅದರ ಪ್ರಕಾರನೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
ನೋಡ
ನಾವು ಪಾಸ್
ನಾಳೆಗೋ ಪಾಸ್ ಅವರು
ನಾಳೆಗೆ ಹಾಕೊಂಡ್ಬಿಡಿ.
ನಾಳೆಗೆ.
I may kindly be, my lord, pardon for insisting upon lordship, my lord.
Why it's your right? ಇದೇನ್ ಪರ್ಸನಲ್ ಇರ್ತದ? ನೀವು ಕೇಸಿನ ಬಗ್ಗೆ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೇವಪ್ಪ, ಕೇಸಿನ ಬಗ್ಗೆ ನಾವ್ ಹೇಳ್ತೇವಪ್ಪ.
ಹಂಗಲ್ಲ, ನೀವು ನೋಡ್ಲೇಬೇಕು ಅಂದಿದ್ದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು.
ಇಟ್ಸ್ ಯುವರ್ ರೈಟ್. ಅದು ರೈಟ್ ಆಫ್ ದಿ ಲಿಟಿಗಂಟ್.
ಅದೇ ಪಾಯಿಂಟ್ ಇರೋದು, ಅದೇ ಅವ್ರು ತಮ್ಮ ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅದನ್ನ.
ಯಾವ ಎಲ್ಲ ತೋರಿಸಿದ್ವಿ ಸರ್, ತೋರಿಸಿದ್ವಿ, ಯಾವ್ದು ಮುಚ್ಚಿಟ್ಟಿಲ್ಲ.
ನಾಳೆ ನೋಡೋಣ, ಪ್ಲೀಸ್ ನಾಳೆ ಬನ್ನಿ. Anyway, we have said one book to be presented. ನಾಳೆ ನಿನ್ನ ಪಾಳಿ. So it will come tomorrow.
ಅಲ್ಲ 2:30 ಹಾಕೋಬಹುದು. ಅಲ್ಲ 2:30 ಹಾಕೊಳ್ಳಿ. Some inconvenience ಮಾಡ tomorrow. Some inconvenience ಮಾಡ tomorrow. ಅದಕ್ಕೆ 2:30 ಹಾಕೊಳ್ಳಿ. I will try to assist your lordship.
ನಾಡ್ದು ಹಾಕೋಣ. ಅಲ್ಲ ಮಂಡೇ ಹಾಕೋಣ. ಮಂಡೇ ಹಾಕೋಬಹುದು.
ಅಲ್ಲ ಮಂಡೇ ಬಿಡು. ನಾಡು 26 ಹಾಕೋಬಹುದು.
26. ಅವ್ರು ಯಾವ ಡೇಟು ಯಾವ ಟೈಮ್ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ ಹಾಕ್ರಿ. ಬರ್ಲಿದ್ರೆ ಮಾಡೋದು ನಮ್ ಕೋರ್ಟಿಗೆ ಅದಕ್ಕೆ.
ಅಲ್ಲ 2:30 ಹಾಕೊಂಡ್ರೆ ಎಲ್ರಿಗೂ ಅನುಕೂಲ. 2:30 ವಿಲ್ ಟ್ರೈ ಟು ಅಸಿಸ್ಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. 2:30 ಹಾಕೊಳ್ಳಿ. ಇವತ್ತು ಪಾಪ ನಾನು ಏನು ರೆಡಿ ಮಾಡ್ತೀನಿ. ಅಲ್ಲ ತಮ್ಮ ತೋರ್ಸ ಸೋ ದಟ್ ದೇ ಕ್ಯಾನ್ 2:30 ಹಾಕೊಳ್ಳಿ. 2:30 ಹಾಕೊಳ್ಳಿ.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿ.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅದನ್ನ ತಮ್ಮ ತೋರಿಸ್ತೀನಿ.
ನಾವು annexure R3 ಅಲ್ಲಿ ನಿಮ್ಗೆ ಇಷ್ಟು ಬರುತ್ತೆ ಪೆಟ್ 2 ಪ್ರಕಾರ ಅಂತ ನಾವು ಆಲ್ರೆಡಿ ಹೇಳಿದೀವಿ. ಇಫ್ ಯು ಹ್ಯಾವ್ ಎ ಡಿಫರೆಂಟ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮೇಲೆ ಎಷ್ಟು
ಇಲ್ಲ ಅಲ್ಲವೇ ಅಲ್ಲ. 2:30 ಹಾಕೊಳ್ಳಿ ದಯವಿಟ್ಟು.
ಆದ್ರೆ ನೀವು ತಾವು ಹೇಳಿ
ಆಯ್ತು. ಅವ್ರನ್ನ ಊಟಕ್ಕೆ ಕರ್ಕೊಂಡು ಹೋಗಿ. ಊಟ ಮುಗಿಸ್ಕೊಂಬರಿ ಇಬ್ರು.
ನಾ ಕೊಡ್ತೀನಿ. 2:30
ಪ್ಲೀಸ್. ಇದರಲ್ಲಿ ದ ಡೈರೆಕ್ಷನ್ ಟು ರೆಗ್ಯುಲರೈಸ್ ಅಂತ ಇತ್ತು, ಅದ್ರ ಪ್ರಕಾರ ವಿ ಹ್ಯಾವ್ ಡನ್ ಅ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಅಂಡ್ ದ ಮ್ಯಾಟರ್ ವಾಸ್ ಲಿಸ್ಟೆಡ್ ಲಾಸ್ಟ್ ಟೈಮ್. ದ ಅದರ್ ಕಾನ್ಸಿಕ್ವೆನ್ಸಿಯಲ್ ಬೆನಿಫಿಟ್ಸ್ ಮಿಲಾಟ್, ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಕೇಳ್ರಿ ಅಂತ. ಅದ್ರ ಪ್ರಕಾರ ಮಿಲಾಡ್ ಬೈ ದ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಲ್ರೆಡಿ ಮಿಲಾಡ್ ಕ್ಯಾಲ್ಕುಲೇಟಿಂಗ್ ಅಂಡ್ ಸೆಂಟ್. ಅಲ್ಲ
ಇವತ್ತು ದುಡ್ಡು ಕೊಡ್ತೀರಿ.
ಅಲ್ಲ ಪೆನ್ಷನ್ ಫಿಕ್ಸ್ ಅದು
ಅಕೌಂಟೆಂಟ್ ಜನರಲ್ ರಿಟೈರ್ಡ್ ಎಂಪ್ಲಾಯಿ ಅವ.
ಅಲ್ಲ
how long he should do? Ask him, your officer, when is he going to make the payment?
That is his role is already completed. Now he has already forwarded the entire paper to the accountant general.
That makes no sense to us. Order compliance ಏನಾಗಿದೆ? ನೀವು ಆ ಟೇಬಲ್ ನಿಂದ ಈ ಟೇಬಲ್ ಹೋಗಿದೆ. ನಾವು ಅದೆಲ್ಲ ಸ್ಟೋರಿ ತಗೊಂಡು ಲಿಟಿಗಂಟ್ ಸಂಬಂಧನೇ ಇಲ್ಲ. ಲಿಟಿಗಂಟ್ ಹೇಳೋದು ನಮಗೆ ದುಡ್ಡು ಕೊಡ್ರಿ ಅಂತ ನಾವು.
ಅಕೌಂಟೆಂಟ್ ಜನರಲ್ ಮಿಲಾಡ್ ನಾರ್ಮಲ್ ಅಲ್ಲ, ತಮಗೂ ಪೆನ್ಷನ್ ರಿಟೈರ್ಡ್ ಆಗಿದೆ ಫಿಕ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು 2 months ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಪೆನ್ಷನ್ ಫಿಕ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಮಿಲಾಡ್ he is now is ಹೌದು ಪೇಪರ್ಸ್ ಎಲ್ಲ ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಮಿಲಾಡ್. ದಿ ರೀಸನ್ ಈಸ್ ಮಿಲಾಡ್, this order for regularization was passed ಮಿಲಾಡ್ on 26/7/24 because he has
first order is dated 2018.
ಇಲ್ಲ
litigation ನೋಡಿ, how long he should be here in the court ಅಂತ ನಾ ಕೇಳೋದು. ಬರೀ ಇದನ್ನ ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ ಕನ್ಸಿಡರ್ ಮಿಲಾಡ್ his representation ಇದು ಅಂತ regularization. That order ಮಿಲಾಡ್ on 18th November 21 ಅಲ್ಲಿ ಪಾಸ್ ಆಯ್ತು. ಇದ್ರ ಪ್ರಕಾರ ಮಿಲಾಡ್
please come to page 17.
Please.
Sorry. Petition allowed impugned endorsement is quashed. Number 2, respondent directed to regularize the service of petitioner in terms of
government order Bengaluru grant all monetary benefits.
Grant monetary benefits, etc.
Please note.
When are you going to make the payment?
Milord, regularization done, monetary benefits already milord papers are followed to accountant general. It's the accountant general milord has to fix the pension and everything milord.
It's only an agency. It's only an agency.
No, milord, my
you tell when you are going to make the payment. you have a conference with the Accountant General Office, then
ಅಲ್ಲ ಅವ್ರು ಕೇಳಿದೆ ನೋಡು ಅದಕ್ಕೆ ಅರ್ಜನ್ 2 months ಪೆನ್ಷನ್ ಬಿಡ್ಲಿಕ್ಕೆ 2 months
2018 order.
ಇಲ್ಲ ಇಲ್ಲ 23 ಮಾಡೋದು ಅದು ಅಪೀಲ್ ಹಾಕಿ
Thereafter, no, first order, kindly see that first, that November 2021 order, kindly come to page 13A.
ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿತ್ತು ಅದು 13th April.
ಅದು ಅವ್ರದ್ದೇನ್ ತಪ್ಪು? ನೀವು ಅಪೀಲ್ ಹಾಕ್ತೀರಿ, ಸೆಲ್ಫಿ ಹಾಕೋತೀರಿ, ರಿವ್ಯೂ ಪಿಟಿಷನ್, ಪ್ರಿವೆಂಟಿವ್ ಪಿಟಿಷನ್ ಎಲ್ಲ ಅಷ್ಟು
ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು ಮೊನ್ನೆ, ಅದಕ್ಕೆ ಲೇಟ್ ಆಗಿದೆ.
ಎಂತ ಮೊನ್ನೆ ಇದ್ರು ಸಹಿತ ನೀವು ಅಂತದನ್ನು ರೆಡಿ ಮಾಡಿಟ್ಟು ಪೆನ್ಷನರ್ಸ್ಗೆ ಸಿ ವಾಟ್ ದ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಸೆಡ್ ಇನ್ ಡಿಎಸ್ ನಕಾರ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ 84 ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
Not only this, my lord, if any person retired, my lord, at least it will take 2, because all the papers, my lord, pension paper has to be forwarded to my lord department. It will take minimum 2 months, 1 month or 2 months to.
Your guideline says you should make all preparation 6 months in advance to the retirement. There is such a judgment.
But that is not in this case, because the regularization order.
ಎರಡು ತಿಂಗಳು ಯಾಕೆ ಬೇಕು? ಯಾವತ್ತಪ್ಪ ನಿಮ್ಗೆ ಆರ್ಡರ್ ಇದಾಗಿದ್ದು, ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು ಯಾವತ್ತಪ್ಪ?
13 September 2023 ಆಗಿದೆ.
ಒಂದು ವರ್ಷ ಆಗಿದೆ ಅಂದ್ರೆ ಅವ್ರು ಹಂಗೆ ಸತ್ತು ಹೋಗ್ಬೇಕು. ತಬರನ ಕತೆ ಮಾಡಬೇಡಿ, ತಬರನ ಕತೆ ಮಾಡಬೇಡಿ ನಮ್ಮ ಮುಂದೆ. You read that novel by KP Purnachandra Tejasvi, son of Kuvempu. What the difficulties of retired people.
It's true, my lord, but order is already complied. It's only payment is, my lord.
1 year ಆಗಿದೆ. ಇದು ಒಂದು ವಾರದಲ್ಲಿ ಆಗ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕರೀತೀವಿ. ಕೀಪ್ ದೆಮ್ ಪ್ರೆಸೆಂಟ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. ಬರ್ಕೊಳ್ಳಿ.
He is not the party, my lord.
ಯಾರು?
Accountant General.
ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. You whatever what you have done, see that ಇಂಥವೆಲ್ಲ ಕಂಟೆನ್ಷನ್ ಎತ್ತಬಾರ್ದು. ಅವ್ರ ಪಾರ್ಟಿ ಇಲ್ಲ ನಾವು ಇದಲ್ಲ ಅಂತ.
The reason is, I am not asking abnormal time. 2 months time, my lord.
1 ವರ್ಷ ಆಗಿದೆ, ಇನ್ನೂ ಏನಾಗಿಲ್ಲ. 1 ವರ್ಷ ಆಗಿದೆ ನಿಮ್ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿ. ಇವನ್ ಪಾಪ 2018 ನಲ್ಲಿ ವಾಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. ಎಷ್ಟು ವರ್ಷ ಯಾಕೆ ವೇಸ್ಟ್ ಮಾಡ್ತೀರಿ ಟೈಮ್? ಅಂದ್ರೆ ಅವನು ಬರೇ ಕೇಸ್ ನಲ್ಲಿ ಅಡ್ಡಾಡ್ಕೋತಿರ್ಲಿ ಅಂತನಾ? ಅವನು ಸತ್ತು ಹೋಗ್ಬಿಡ್ತಾನೆ. ನೋ ನೋ ನೋ, ಯು ಕಾಂಟ್ ಸಿ ಡಿಎಸ್ ನಕಾರ, ಸಿ ವಿಚ್ ಇಸ್ ದಟ್ ಫೇಮಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ದೇವಕಿ ನಂದನ್ ಪಾಸ್ವಾನ್, ಮಿಶ್ರಾ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಬಿಹಾರ್ ಏನಂತ ಹೇಳಿದ್ದಾರೆ.
ಬಟ್ ಅಟ್ ಲೀಸ್ಟ್ ಪೆನ್ಷನ್, my lord, pay the pension.
ವೀಕ್ ಟೈಮ್ ಕೊಡ್ತೀವಿ. 1 ವೀಕ್ ನಲ್ಲಿ ಯು ಪ್ರೆಷರೈಸ್ ಯುವರ್ ಅಕೌಂಟೆಂಟ್ ಜನರಲ್.
No, I have done it, my lord. We already done. They saying that
2 ತಿಂಗಳು ಕೊಡಲ್ಲ, 1 ವಾರದಲ್ಲಿ ಮುಗಿಬೇಕು. ಏನ್ರಿ ಒಬ್ಬ ಆರ್ಡಿನರಿ ಪರ್ಸನ್ ಅಂದ
4 weeks ಕೊಡಿ ನೋಡು.
Finally, a period of 1 week is granted for reporting compliance, in the sense that the pension papers should be completed. The pension and arrears of pension should reach the hands of the victorious litigant in the battle, legal battle, full stop. Comma, failing which stringent action may follow against the concerned quarters. This order we have structured in keeping in view the decision of the apex court in Devaki Nandana Mishra versus State of Bihar and DK Nakara, DS Nakara versus Union of India. Okay. September.
But the state had undertaken to redress the situation and also to comply the order of this honorable court.
What was the order, Mr. Hegde?
Lord, sanction was to be granted by the state government and the municipal corporation was to execute a registered sale deed in my favor. And the.
Yes.
There is a.
You were a party.
Yes.
Please.
You were a party to the original proceeding and in the appeal also.
Please, madam. The direction, madam, is earlier. You see the earlier order.
Yes.
This honorable court has already settled that.
12/9/2024 order.
I gone through it.
Yes.
After that order, madam, I was communicated to the under secretary to urban development. Since initial stage, they rejected for granting approval. But my lords, in earlier order, irrespective that was overtaken by and saying that in spite of that order, you have to give the undertaking, grant approval.
Compliance ಬಗ್ಗೆ ಹೇಳಿ.
My lord, I requested many, after communicated this order, earlier order also last date order, but they still may not saying that it's still under the taking the legal opinion ಅಂತ ಅವರು reply ಮಾಡ್ತಾರೆ.
The second accused, Srimati Deepa Cholan, who happens to be Principal Secretary, Department of
Urban Development,
Urban Development, Government of Karnataka, was arraigned on ಯಾವ ಡೇಟಿಗೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ತು?
ಅಲ್ಲ ಮೊದಲೇ
12/9/2024, regard being had to the pivotal role that she has to play in the case in terms of the
ಅದಕ್ಕಿಂತ ಮೊದಲೇ ತಾವು ವಾರ್ನ್ ಮಾಡಿದ್ರು
in view of her succession to the office. First up, ಏನ್ ಬರಿಬೇಕು ನಾವು? ನೀವು ಹೇಳಿದ್ದನ್ನು ಬರಿಬೇಕೋ ಏನೋ ಅಥವಾ ಏನಾರ ಸ್ವಲ್ಪ?
ಅಲ್ಲ ಅವ್ರಿಗೆ ನಾನು ಸೀರಿಯಸ್ ಆಗಿ ಮಿಲಾಡ್ ಕಮ್ಯುನಿಕೇಟ್ ಇದ್ದೆ,
learned
ಹಾಕಿದ್ದೀನಿ ಸೀರಿಯಸ್ ಆಗಿ
TA submits that.
ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮೊದಲೇ ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀರಿ 20 ಮಿಲಾಡ್ ಯು ಸಿ ದ 28/8/24 ಆರ್ಡರ್.
The
28/8
the order dated 28/8/2024 reads as under.
ಅದರಲ್ಲಿ ತಾವು ಈ ಒಂದು ಮಿಲಾಡ್
In the said order, warning was administered to the secretary, principal secretary to Government Department of Revenue ಆಗಿತ್ತು.
ತಪ್ಪಾಗಿತ್ತು, ಬಟ್ ನಾನು ಕರೆಕ್ಟ್ ಆಗಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ದೆ.
Revenue. Although learned government advocate on our request had communicated
Urban
to
Secretary
the secretary, principal secretary, Department of UD.
Urban.
UD. First. Next paragraph. On 12/9/2024, we had said as under. First. Learned GA appearing for the freshly arraigned accused Srimati Deepa Cholan submits that despite sending communication, there is no response from the principal secretary, present incumbent of the office of principal secretary of UD. First off, this is not a happy thing to happen. First off, ordinarily, we do not call officials to the court since they are represented by their advocates. First off, advocates, consistent with the view of the apex court in a catena of decisions. First off, however, exception is also made in those decisions, and the case of the said respondent accused fits into exception, since she is not responding to the communication of her lawyer, government advocate. First, next part, in view of the above, we direct the second respondent accused, Srimati Deepa Cholan, to be personally present before the court. Now date.
ನೆಕ್ಸ್ಟ್
ನಮ್ಮ ಮುಂದೆ ಆಗ್ಬೇಕು
ಅದು ಮಂಡೇ ಮಂಡೇ
26
ಟು ಅರ್ಲಿ
earlier.
20 30th
27th. However, in the meanwhile, if the order is complied with and report is sent, her presence shall not be required.
ಪ್ಲೀಸ್.
ಅವತ್ತು ಬಿಜಿ ಇದ್ದೀವಿ ನಾವು.
ಅದು ಮಂಡೇ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ
ಹಾಕೋಣ.
ಮಂಡೇ
ಮಂಡೇ
30th. ಅದೊಂದು ಸ್ವಲ್ಪ ಕಾಪಿ ನಮಗೆ ಕೊಟ್ಟರೆ
Registry to share a copy of this order with the learned GA and with the other advocates in the matter.
Your Lords, appear for the complainant, Your Lords, that.
Serial number 15, I appear for respondent.
Yes.
15, my lords. My lords, we had communicated with the complainant via letter dated 21 September 24 and had asked him to collect the payment. But there seems to be an issue, collect the payment, but he seems to have some issue with regards to the quantum. He is seeking additional benefits, additional statutory components. which are outside the purview of the order impugned in the contempt petition.
Amount isಕೊಳ್ಳಿ ಈಗ without prejudice to
Yes, sir.
prosecuting the contempt matter.
With the your lord's liberty to revive the complaint, because there is the specific direction by this honorable court in view of this Union of India versus Tarsim Singh, your lords. I'm entitled for the solution and other benefits that they are not ready to give.
2012.
Yes, your lords. So 19(9) SEC.
That's 19 judgment.
Yes, my judge.
That's what, your lords.
ಅದನ್ನು ಕೊಡ್ಬೇಕು. You have to pay that also.
My lords, the compensation that we are depositing is inclusive of the benefits under land acquisition, which the Tarsim Singh judgment allows. Section 3J of the National Highways Act was struck down, thereby making section 23(1)(a) and 28 of the Land Acquisition Act applicable.
There should be pause between two sentences.
I'm sorry, ma'am.
You are not narrating a poem.
I'm sorry.
You are not
ma'am.
citing poem, because we have to assess each of your
My lords.
sentences.
I
Now,
apologize.
yes, which is your bank account number?
Yes, your lords.
Bank account number.
Bank account number, I'll get it.
But you ask your client to credit that money immediately to the bank account. We are
My lords.
passing over. Bank
My
account.
lords.
And with the liberty to revive the complaint if I'm
So
not
many
satisfied.
ಮೊದಲು
Yes,
ದುಡ್ಡು
your
ಮುಟ್ಲಿ ಅವರಿಗೆ, ಲ್ಯಾಂಡ್ ಕಳ್ಕೊಂಡವರಿಗೆ.
yes, your lords.
Pass over. Yes. Ask your client to be ready with the money.
My
Instruction
lords.
to your banker. Yes.
My lords, my
Pass
lords.
over. We are calling it again.
Grateful, my lords.
ಏನಿದ್ರು ಚಿಕ್ಕನರ್ಗೊಂದು?
Filing affidavit. 20, running page 28 is the order.
ಏನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದು?
ಅವರು ರೆಗ್ಯುಲರೈಸೇಷನ್ ಕನ್ಸಿಡರ್ ದ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಅಂತ ಕೇಳಿದ್ರು.
Approval of the appointment, your lordship.
Approval of appointment.
Appointment, your lordship.
Page number?
Of the page number.
28, order portion is 36.
36, your lordship.
He has been serving with effect from 8/6/95.
95, lordship. Please, your lordship.
ನೋಡ್ಲಿ.
This is the fourth round of litigation, your lordship.
ಎಷ್ಟು ಸರಿ ಬಂದ ನೀವು ಕೋರ್ಟಿಗೆ?
This is the more
ಸಲ ಬಂದಿದೆ.
Times.
ಅಲ್ಲ ಅದು 3 ಸಲನು ಅವರು the reason is my lord, his case is kindly see my lord, he was appointed year 1995.
Correct.
But he was my lord secured the B.Ed degree, which is the qualification. He obtained the year 2004.
Please read.
Please.
So far as legality of the appointment is concerned, matter is closed. You can't go behind the order here. See that?
Please.
See that. It cannot be said that his appointment is
Well,
bad
absolutely.
or illegal at this point of time.
Please.
Therefore, you have to take it that he was fully qualified when the appointment was made. On that premise, you have to operate.
And
You cannot give open certain things.
36 ಅದಕ್ಕೆ ಆರ್ಡರ್ ಪೋರ್ಷನ್ my lord. What is the order ಅಂತ?
Correct.
The writ petition is allowed, the impugned order so and so fourth
Matter remanded for fresh consideration
consideration.
in the light of what is said.
Yes my lord. ಅದಕ್ಕೆ reconsider madam, we have given a detailed reasoning ಯಾಕೆ
ತೋರ್ಸಿ. ಅಂದ್ರೆ ಇನ್ನೂ 25 ಕೇಸ್ ಹಾಕ್ಲಿ ಅಂತ.
ಅಲ್ಲ ಅವರು ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಟ್ ಪಾಸಿಟಿವ್ ಕೊಟ್ರೆ my lord,
Positive
there
ಇದೆ.
is no issue at all.
ಪಾಸಿಟಿವ್ ಇದೆ. ಅದ್ರಾಗ ಏನು ಇಷ್ಟೊಂದು ಪಾಸಿಟಿವ್ ಅಂದ್ರೆ ಬೇರೆ ಏನ್
ಪಾಸಿಟಿವ್ ಅಂದ್ರೆ again my lord is sending back to reconsideration to the authority.
ಒಂದು ಏನೋ ನಿಮ್ಗೆ ಒಂದು ಅಪರ್ಚುನಿಟಿ ಅದು ಟು ರೆಕ್ಟಿಫೈ ಯುವರ್ ಸೆಲ್ಸ್. ಆ ಅಪರ್ಚುನಿಟಿ ಮಿಸ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಆಗ್ತದೆ. ಅಬ್ಯೂಸ್ ಆಫ್ ಪ್ರೋಸೆಸ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಇಸ್ ಅ ಕಂಟೆಂಪ್ಟ್. ಎಷ್ಟು ಸರಿ ಲಿಟಿಗಂಟ್ ಎಷ್ಟು ಸರಿ ಬರ್ಬೇಕು ಕೋರ್ಟಿಗೆ? ಬರೀ ಇದನ್ನ ಮಾಡ್ಕೊತ ಕೊಡ್ಬೇಕು ಏನೋ ಅವನು. ಇಫ್ ದಟ್ ಇಸ್ ದ ರೀಸನ್ ದೇ ಲೂಸ್ ಫೇತ್ ಆನ್ ಅಸ್. ನಾವು ಅಷ್ಟಕ್ಕಷ್ಟೇ ನೀವೆಂಕು ಇನ್ನೂ ಆತ.
But we have stated all the earlier my lord extracted. My lord, 10 ಅಲ್ಲಿ ಲಾಸ್ಟ್ what is the rule my lord we have extracted? ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ 8ರಲ್ಲಿ ಕರ್ನಾಟಕ ಪ್ರೈವೇಟ್ ಏಡೆಡ್ ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಎಂಪ್ಲಾಯಿ ರೆಗ್ಯುಲೇಷನ್ಸ್ 2000 rules 2, which is not suiting anything contained in the order of the government or any judgment or any court of law, the claim counting prior to the date of admission.
Ask your officer to be personally present. ask them to be personally present. They cannot play with the orders of the court. What is this they are doing?
Not,
Can there be more clear order than this? We remanded the matter because court has shown grace to you. Very gracefully court has done that. You cannot abuse the grace of the court. Ask them if they are here, ask them whether they want to comply or not.
DDPI is there.
We will frame the charge. We will frame the charge. We will not only punish them, we will levy, we will inflict bad injury, legal injury on them.
It is the first respondent accused has to apply the order.
Our first respondent, who? Can't play with. Why we do not, we cost jurisprudence is not developed in this country because of this, all these things are happening. Because you will be available to defend their action. So they think we will commit error. Somebody will defend our action.
After seeing the order, my lord, I told them, once an order is set aside.
Ask, who is that person?
My lord, he's
Ask him generally, we do not call people because Apex Court has said, don't call the officials to the court. That's right. That we agree. We are also another branch of the state. They are also branch of state. We should coordinate and respect each other. But respect should be shown by the department. No, if not respect, at least deference has to be shown to judicial orders. Ritesh Kumar Singh, the principal secretary, who happens to be the first accused. Srimati Jayashree Shintri, Additional Commissioner of Public Instructions, who happens to be the second accused, and Mr. M.A. Radder.
But he is present, my lord. He is already retired, but both the present and Redder and present incumbent is also present.
Ibru retire agara?
Illa, obru idare.
Srimati is still there.
Avaru idare.
And so and Srimati so and so shall be personally present.
1 and 2, my lord.
Personally present before the court on Monday. Since they have made the successful litigant in the successful party in the legal battle to approach the court fifth time, despite having secured five times. First time, the litigation, this legal battle is being fought since last quarter century or so. So, nothing material having fallen at the hands of the victorious litigant. First time. In view of the above, they are directed to be present before the court. The structure personally present before the court. Next paragraph. However, in the meanwhile, if they comply with the order in its pith and substance, their presence may not be required. Personal presence may not be required. It's not a good thing to happen. This is a welfare state number. Constitution ordains welfare state. It's not a East India Company. We have established a welfare state. Welfare state means the government should conduct itself as a model employer anta helide Supreme Court. Model employer hinge nadkutana aa reeti, not some factory owner. Government ಇದು ಎಷ್ಟು ತ್ರಾಸ ಕೊಡ್ತೀರಿ? 2010ರಿಂದ ಫೈಟ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಲಿಟಿಗಂಟ್. ಎಲ್ಲ ಕೇಸ್ನಲ್ಲಿ ಸಕ್ಸಸ್ಫುಲ್ ಆಗ್ಯಾನ. ಎಸ್.
IPF of the complainant. Plus the complainant had retired
My lord,
way
I will
back.
take notice for the second respondent, my lord, who's not yet served, but I will take notice. I will file wakalat today or tomorrow. The lordships may kindly give me some time, my lord, to submit regarding the.
Let us see how the litigation went at least. We'll give you. Wait.
The complainant had retired on 31/7/2020.
Pensionary benefits.
Pensionary benefits. They undertook before this honorable court to an extent of saying that within 2 months, the accused number 3 will forward the papers to the accused number 1. And from there, within 3 months, the accused number 1 pensionary benefits. That was the undertaking. Lords, order was passed on 9/12/2023. She has retired in the year 2020.
ಲೋಕ ಅದಾಲತ್ ಮುಂದಾಗಿದ್ದಿದ್ದು.
ಹೌದು, but my lord, I am for the management, second respondent.
But there is a duty on your part also.
Yes, my lord. My duty is on me only, not on the principal who had appeared before the Lok Adalat. ನನಗೆ writ ನಲ್ಲಿ notice ಆಗಿಲ್ಲ. I have not participated in the Lok Adalat proceedings.
Your principal participated.
Yes, my lord, he has participated, but he, my lord, has written to the management. But there are some issues, my lord, against the past principal, which have to be addressed. There is a matter pending before the Lokayukta.
Yes.
She has withdrawn money after her retirement. Self-check haki, she has withdrawn money from the account of the
You take
college.
action. You can, you have power to withhold the pension also.
No, my lord. My submission is this. I have to send a proposal to the government stating that there are no cases pending against her.
All right.
And
Then
then
we'll give you 2 days now, not beyond that. Barkali, call this matter on Monday at the request of Shri Harsh Desai, who appears for respondents 2 and 3, na?
Allah, 2.
2.
3, my lord, already my learned friend is appearing.
Plus 1 is Regional Joint Director, Department of Collegiate Education. Here, he is served with the notice.
Shri Girish Lanet GA on instructions appears for first respondent, huh? First respondent. Call this matter on Monday.
Lord, can I request, my lord, the day after tomorrow, 20?
After tomorrow.
After tomorrow.
All right.
Monday, my lord, I am not
26.
here.
No problem. 26.
Please. And my lord, can I request the matter to be listed along with my writ petition, my lord, which I have filed
You have filed writ petition.
against the order of the Lok Adalat? It may be clubbed and disposed of together.
Allah.
Writ now.
That is
Allah, it is before the division bench.
before the division bench.
It is before the division bench because, my lord, the order is passed by the High Court.
High Court Lok Adalat.
ಹೌದು, ಅದಕ್ಕೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆನೇ ಇದೆ. It could be heard, my lord, together.
Call this matter day after, along with the writ petition number so and so.
In the meanwhile, let them serve me a copy of the writ petition.
Copy ಕೊಟ್ಬಿಡಿ ಒಂದು ಅವರಿಗೆ.
Okay. Yes, my lord, I will do it today itself.
Okay.
Let's IPO for the complainant. The order has been complied with.
Counsel for the complainant in all fairness submits that the order whose violation is complained of has been complied with. First, in view of the above, the contempt proceedings are
File
dropped.
affidavit of compliance affidavit.
Complied with the sentence ಬರೀಬೇಕು. Shri K.L. Patil appearing for the answering respondent.
Number 1, invest.
Draws attention of the court to the compliance affidavit. ಇದು ಮೊದಲು ಹಾಕೊಂಡು ನಂತರ ಸೆಕೆಂಡ್ ಅನ್ನು ಅವ್ರು ಹೇಳಿದ ಹಾಕೋಬೇಕು. Dropped. No cause.
ಇದರಲ್ಲಿ I will take notice for respondent, my lord. First, I need some time, my lord, to file, my lord. I have taken instruction. ಅವ್ರು ಏನೋ ಕಂಪ್ಲೈ ಮಾಡ್ತಾ ಇರೋದು. ಸ್ವಲ್ಪ ಟೈಮ್
ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡ್ತೀರಾ?
ಮಾಡ್ತಾ ಇದ್ರು.
ಬರ್ಕೊಡಿ. ಮೆಮೊ ಕೊಡಿ.
ಆಫೀಸರ್ಸ್ ಇದ್ದಾರೆ.
ಹೇಳಿ ಕೆಂದ ಬರ್ಸ್ಕೊಡಿ. ನಾವೊಂದು ರೆಕಾರ್ಡ್ ಮಾಡ್ತೇವೆ, ರಿಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೇವೆ. ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿದ್ರೆ ಅಗ್ರಿವೇಟೆಡ್ ಕಂಟೆಂಪ್ಟ್
ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅದಕ್ಕೆ
ಅಲ್ಲ, ನಾನು ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ರೆ ಅದನ್ನ just give me some time, my lord, already.
Allah, we believe you that we will say that they are complying. Anyway, everything is recorded. You can play the.
Order was passed, my lord, in October 2023. Time fixed by this court was, my lord, 2 months.
They know what this court will do if compliance is not done.
ಅದನ್ನ ಮಾರ್ನಿಂಗ್ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದನ್ನು ತರಿಸಿದ್ರು.
83 years old person. Fifth time, my lord, he is before the court.
Last.
ಏನಂತ ಆರ್ಡರ್ ಮಾಡಿರಿ
ತಾವು? Last, the finance department note yesterday, I think.
As a special case, you are making payment.
Payment ಮಾಡ್ತಾರೆ.
ಅವರಿಗೆ ಒಂದು ಸೇರ್ ಮಾಡ್ಕೋಬೇಕು.
ಅಂದದು ನೋಟ್ ಇತ್ತು. ಅಲ್ಲ ಅದು ನೋಟ್, my lord. That is a finance.
ಅದೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬಹುದು ತಾನೆ?
ಮಾಡು. ಪ್ಲೀಸ್ ಮಾಡ್ತೀನಿ.
SLP ಎಲ್ಲ ಆಗಿದೆ.
ಎಲ್ಲ ಆಗಿ ಸೆಕೆಂಡ್ ರೌಂಡ್
ಇಲ್ಲ ಇದು we already paid, my lord. ಅವರು ಲಾಸ್ಟ್ ಎಂಟೈರ್
The complaint is the as to whether while non-compliance of order dated 3/10/2023 rendered in complainant's WP number 102001 of 2023 SKST. Learned counsel for the complainant submits that matter was carried to the apex court by the respondent side, and even there his client emerged victorious. First off, he further submits that despite all this, the order is not being complied with, and therefore respondent should be tried and punished for the offense of contempt of court, punishable under sections 1112 or 1011, 1112 of Contempt of Courts Act 1971. First, learned GA appearing for the answering respondent's stroke accused has placed on record a copy of the
note ಇದೆ ಅದೇನ್
GA reads out the file note number. ಈ ನಂಬರ್ ಎಲ್ಲ ಇದೆ, ನಂಬರು ಡೇಟು ಇದು ಹಾಕೊಂಡ್ಬಿಡು, so and so which is as under, okay, ಇದನ್ನು ಹಾಕೋಬೇಕು. First up, next one, learned GA assures that the case of the complainant is treated as a special case and that amount is being released, sanctioned and released in terms of the court order within 4 weeks. Within 4 weeks.
4 weeks.
Within 4 weeks. First up. Next one, in view of the above assurance, these proceedings are dropped with liberty to the complainant to seek their revival for aggravated form of contempt in the event the assurance is not kept.
The assurance in the presence of officers was
assurance.
ಅಲ್ಲ ಅವರೇನು ಹೆಸರು ಬೇಡ ಅವರು, because they are not the accused, they are low level ಇದು
one sentence add ಮಾಡಿ. The learned GA has made this submission on the instructions of the officials present before the court.
May I make one more request, my lord? This, after the apex court order, my lord, there was 2 more proceedings initiated by me for want of, my lord, calculations. So therefore, my friend may be kind enough to furnish the calculation on what way they have, my lord, calculated.
That's how governments work. That's how they are. As friendly ಇರಲ್ಲ ಅವರು, citizen friendliness ಅನ್ನು ಕಲಿಬೇಕು ನಾವು. ನಾವು court ಆಯ್ತು, other organs of the state ಆಯ್ತು. We are not citizen friendly, subject friendly ಇಲ್ಲ ನಾವು. ಏನೋ ಒಂದು ನಮ್ದೇ ಗ್ಲಾಸ್ ಹೌಸ್ ನಾಗ ಇದ್ದೀವಿ.
ಏನ್ ಮಾಡ್ತಾರೆ, ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ರೆಮಿಟ್ ಮಾಡ್ತಾರೆ, ನಮ್ಗೆ ಅದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹೇಗ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದೇ ಗೊತ್ತಾಗೋದಿಲ್ಲ. ಇನ್ಫ್ಯಾಕ್ಟ್ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್.
ಹಂಗೆ ಜಸ್ಟ್ ನೋಡಿ ಗ್ಲಾನ್ಸ್ ಇತ್ತು, ಏನೋ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಬರ್ದಾರ, ಮತ್ತೆ ಅಲ್ಲಿ ತಪ್ಪು ಮಾಡಿ ಮತ್ತೊಂದು ಕೇಸು. Nariman, Mr. Fali Nariman has narrated an incident in his Before the Memory Fades. He gives it as an anecdote that Hanuman went to in Ramayana, Hanuman went to Lanka, and thereafter he claimed a certain traveling allowances, etc. They said to go abroad traveling allowance is not permissible. Thereafter Hanuman went and did something, and the version was changed. Lanka is after all part of it, our culture, therefore permission granted. He quotes similar, somewhat in a different way. He has quoted it in his autobiography. Yes.
Alleging, my lords, disobedience of an order dated 21/2014, my lords, passed by the Honorable Single Judge, which was challenged, my lords, by the respondent state in a writ appeal. Writ appeal is dismissed, against which SLP is filed, and the SLP is also dismissed.
What was the order?
Please, my lords. Order was the petitioner happens to be a sugar factory, my lords, and my lords,
ಒಂದು ಪಗ್ಲ ಹಾಕಿ, ಎರಡು ಸೇರಿ ಒಂದು ಪಗ್ಲ ಹಾಕಿ, ಒಂದು ಕಡೆ AC ಹಾಕಿ.
ಇದರಲ್ಲಿ This, even though I filed affidavit, my lord, I'll take instruction. The reason is, my lord, the order is in there 2015. And that was,
The operative portion, my lords, the order is at page number 63, in page 63. Last paragraph, may I read? 63, last paragraph, my lords. There is yet another justification in the petitioner's claim. Though the situation of unharvested sugarcane crop remains, even at the end of the sugar season during 2006-7 was a common feature in several reserved areas of Ballari and other districts in the state. Not all sugar factories were foolhardily to venture to crush such cane. The state government had in those cases said to have paid the growers the said subsidy at the rate of rupees 25,000 per hectare. Therefore, it would be unfair to punish the petitioner for playing the good Samaritan in the interest of the growers in the reserved area. And the direction was issued, my lords.
9 years have happened. 2015.
contempt now is just take some instruction, my lord, because the reason they filed affidavit, because ground for, my lord, applicable section 20, but I am not taking that ground, my lord. I will take some instruction and I will come back to my lords.
This case, before incentives were received, my lords,
Next week, my lord.
No,
2
before
weeks.
before we wind up from Dharwad, things should happen.
Please. One more submission. 2014, I was held to be entitled, my lords,
On
for the
this
incentives.
On next week, Wednesday.
Wednesday 11.
Somar this.
I'm also entitled for interest, anta my submission. I'm also entitled for interest since 2000.
Please, let us see what he will do.
Please.
9 years have lapsed, and you have lost the battle in appeal in before the SLP also.
And in appeal, there is an undertaking. Within 2 months, they will comply.
That's
Please. Oblige.
Matrimonial matter, my lords, where there was a direction, my lords, for the parties to be present before the court. He's online. He's online.
Unmute. ಒಂದು ಬೋರ್ಡ್ ಬರೆದಿಡ್ಬೇಕು ತೋರಿಸ್ಲಿಕ್ಕೆ ಅವ್ರಿಗೆ ನಮ್ಮ ಮಾತು ಕೇಳ್ತಿರಲ್ಲ ಒಂದೊಂದ್ಸರಿ.
ತಮ್ಮ ಕೇಳ್ತಾ ಇದ್ದೆ ಸಾಹೇಬ್ರಿ. ಕಳೆದ ಬಾರಿ ತಾವು ಅವರು ಪ್ರತಿವಾದಿ ಎರಡರಿಗೆ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರಾಗಬೇಕು ಅಂತ ಹೇಳಿ ಆದೇಶ ಮಾಡಿದ್ರಿ.
ಯಾರು ಅಪೋನೆಂಟ್ ಯಾರು?
ನಿಲೋಪನ್.
Pass over.
Please.
We'll give one chance.
Please.
Pass over. Not.
She's here.
Yes, yes, madam.
Sorry, my lords.
You take rest.
He's here.
Perhaps you have come running.
Yes,
Take rest. We'll call afterwards. 10 minutes.
please.
Okay. 10 minutes, Mr. Gurmat.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ, ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
Prepare some briefs enough.
ಈಗೇನು ನಮ್ಗಾಗಲ್ಲ ಬ್ರದರ್. We are in the mid of hearing parted matters ಎಲ್ಲ ಇದೆ. We'll have it immediately after vacation. Immediately after vacation. We're in the mid of this one.
Recalling the order. Recalling the order. Dismissed for default, my lord. I was not in the country.
Steps were not taken for R5, my lord. That is respond number 1. I don't have any objection to recall, but fact, my lord, my application was listed for thrice. He did not made any arrangement to appear. So their lordships without any option.
The appeal was dismissed by the coordinate bench by order dated 5/7/2024. First off, appellant has moved an application in I number 2 of 2024 seeking recall of the said order. Application is supported by an affidavit, and the counsel for appellant submits that he was abroad during the relevant period. First stop. Counsel appearing for the respondent very gracefully tells the court that he has no objection for recalling the order of dismissal and restoring the main matter to the board for consideration on merits. First off, this is really appreciable. Next one, in view of the above, the application having been favored, the dismissal order dated 5/7/2024 having been recalled, the main matter is restored to court.
My lord, interim order was there.
No, it is there.
May please.
1 week time, 1 week time, 1 week as an outer limit is granted for taking steps.
Lordships, my application was listed as then for withdrawal of 50%. Age of 78 and 89 parents are there. That respond number, that is 5 and 6 herein. They, and school going children are there. They are-
Interim.
1 week time ಕೊಟ್ಟೆವು ಅಷ್ಟೇ.
That is the reason the wife of the deceased is R1, my lord. After the award, she remarried. She is not known, even my appeal, she is not known, my lord. So I filed an application. Their lordships were very pleased to grant, but my lord, my application to withdrawal of the amount, my lord. He has deposited.
Deposit ಮಾಡಿದ್ರೆ order.
Yes, man. I have given in the details, man.
Challenge, man.
No, not liability.
It is also challenged.
No, quantum, man.
No, there was a collusion, contributory negligence was there.
Contributory negligence, not collusion. Contributor of the deceased, FIR charge sheet ಎಲ್ಲ ಅವ್ರ ಮೇಲೆ ಇದೆ. Nothing is there as such. And as per the chat Lok Adalat,
Immediately after vacation.
my apprehension is that 89% age parent is
Nothing
without
happened
age
within
source.
a few days. Yes.
My lord, a date may be.
16 ಹಾಕಿ.
My lord, connected, my appeal is there, I'll furnish.
My lord, I am appearing for the appellants, my lord. My lord,
Yes,
the appeal has
Mr.
been, my lord, the appeal has been filed under section 37 of the Arbitration and Conciliation Act, my lord, for setting aside the judgment passed by the learned district judge Haveri, my lord, in arbitration petition number 78 of 23, my lord. The only question of involved in this case is, my lord, the district judge has modified the award, my lord, under section 34. Under section 34, the court has limited jurisdiction, my lord. The court can either confirm the award or set aside the award, but the court has modified the award of the arbitrator, my lord.
But that view appears to be loosened now.
My lord,
The court cannot modify the award
please, my
in
lord.
appeal. Is under 34 is loosened now. Look into
No,
the
my lord.
latest judgment and come back.
No, my lord, I will produce on judgment, my lord. Next time, one date may be given, my lord.
All right. After vacation.
Please, my lord.
Request.
Lords, appeal has been preferred by the husband, my lords, against dismissal of restitution of conjugal rights. Notice has been. Yes.
Owner appeal, my lord, on the ground of liability. 20 lakh is awarded, my death of a bachelor. 25% of the awarded come. 5 lakh. 5 lakh.
When counsel for the appellant submits that this appeal is filed by the owner of the vehicle involved in the accident, he volunteers to deposit his 5 lakh within a period of 8 weeks.
Please.
Take submission in place on record, issue emergent notice on I-1 of 24 as well as on meanwhile, the trial execution court is requested not to proceed with the execution proceedings. Appeal. If this amount is deposited before this court, registry is requested to invest the said amount in fixed deposit for an initial period of 1 year. The National Insurance Act now, registry is instructed. NAR particular requested to accept notice for R6.
Please.
Owner's appeal also challenging the owner's appeal challenging contributory negligence in a notice may be issued also. I have not.
Notice on I-1 of 24 as well as.
Please.
Small issues is not in the writ appeal. While my lords are there, respondent number 1 is a working
in a scientific officer in atomic energy at the age of
ನಮ್ಗೇನೀಗ ಆಗಲ್ಲ. We are in the mid of framing that, that complex matter.
imprimatur regarding
Imprimatur ಇದೆಯಾ?
ಇಲ್ಲ that is what
ಏನು ಕಂಟೆಂಪ್ಟ್ ಏನಾರ ಆಗ್ತಾ ಇದ್ದೀರಲ್ಲ?
Contempt is not filed, my lord, but
Next week,
notice was filed, legal notice was issued. Legal notice was issued.
2 weeks ತನಕ ಮಾಡ್ಕೊಳ್ಳಿ. Please call this matter after 2 weeks.
16 ಅಥವಾ 15 at 16:10 ಏನಿದೆ.
After, in the third week of October.
Please.
On request.
My lord, learned single judge has dismissed the writ petition on the ground that the petitioners who are the landowners, land losers have to approach the authority under section 65. Though, my lord, it may have to be read as section 64. Still, my lord, section 64 does not apply in as much as the petitioners are claiming supplementary award for the purpose of, my lord, fruits, trees and, my lord, the buildings, etc. Now the award is passed.
Supplementary award ಮಾಡ್ಲಿಕ್ಕೆ ಏನು provision ಯಾವುದು?
Yes, section 29, and there are two judgments of the Honorable Apex Court. Section 29, determination of the value of things attached to the land or building. Separate award has to be passed.
Once award is paid, after it will become
Functus of issue ಅಂತ hold ಮಾಡ್ಯಾರೆ.
No, in fact, my lord, these, in fact, considering these two judgments of the Honorable Apex Court, my lord, learned single judge in other matter where I appeared has directed the authority to pass separate award in respect of, my lord, the trees and, my lord, other structures in the land. Section 29 also, my lord, requires. Please.
ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅದು ಬೇರೆ
Supplementary
consequence
award.
ಆಗ್ತದೆ.
Supplementary award, my lord, in addition to.
Power ಅಂತ.
Section 29, my lords may kindly take. Determination of value of things attached to the land or building. The collector in determining the market value of the building and other immovable property or assets attached to the land or building which are to be acquired, use the services of a competent engineer or any other specialist in the relevant field as may be considered necessary by him. The collector, for the purpose of determining the value of the trees and plants attached to the land acquired, use the services of experience.
Regular award ಯಾವ section ಕೆಳಗೆ ಮಾಡ್ತಾರೆ?
Now, my lord, under the new act, it is passed under, my lord, section 26. So after 26, my lord, 29 is provided.
ಯಾವ್ದಾರ ಕೋರ್ಟ್ಗಳು ಇದನ್ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ಯಾವ?
Yes, my lord, that's what, my lord. Two judgments of the Honorable Apex Court, though, my lord, under the earlier act, but now under the new act, one of the learned single
Section
judge-
itself is separate.
Yes, my lord, in the case of Ambakala Matre, the Honorable Apex Court, my lord, in paragraph 34,
ಹೌದು 29 ದಲ್ಲಿ
held that, my lord, separate award has to be passed.
value of things attached to land or building ಇದನ್ನ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು. Award ಅನ್ಕೊಂಡಿಲ್ಲ.
What is the
Please.
mandate of parliament that he should pass a different award or something?
Not separate, those have to be valued separately
Something is.
and award has to be passed. So other, in consideration of that, my lord, what the authorities do is, if it is not taken into consideration while passing the award, they pass a supplementary award in respect of those. Please go.
Complication.
Relying,
29 is not award.
it's not award.
To be done.
He has to take, yes.
And ಈಗ ಬೇರೆ other
ಅದನ್ನ
affixed
ಸೆಪರೇಟ್ಲಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಬೇಕು ಅಂತ
ಅಷ್ಟೇ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಬಗ್ಗೆ ಹೇಳ್ತದೆ. ಅವಾರ್ಡ್ ಎರಡು ಮಾಡಕ್ ಪ್ರಾವಿಷನ್.
ಸೆಪರೇಟ್ಲಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ನಾವು ಕನ್ಸಿಡರಿಂಗ್ ದೀಸ್ ಟು ಜಜ್ಮೆಂಟ್ ಅದು ಕೊಟ್ಟಿದ್ದೀನಿ, ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 34.
ಅದು ಬೇರೆ ಕಾಂಪ್ಲಿಕೇಶನ್. ಈ ಕೇಸ್ನಲ್ಲಿ ಹಂಗೆ ಮಾಡ್ಕೊಳ್ಬೋದು ನೀವು. ಆದ್ರೆ ದಟ್ ವಿಲ್ ಗಿವ್ ನಾಟ್ ಮೆನಿ ಲಿವರೇಜಸ್ ಟು ದಿ ಇದರಲ್ಲಿ.
Paragraph number 34.
Under the old act.
This was under the old act. Now I'll substantiate more. This was considered recently also by the Honorable Apex Court. Para 34. The High Court has also held that once compensation is awarded for the land, there cannot be additional or separate compensation for the trees. For this purpose, the High Court has relied upon the following observations of this court in state of Haryana versus so and so. It is settled law that the collector or the court who determines the compensation for the land as well as fruit bearing trees cannot determine them separately. Compensation is to the value of the acquired land. Market value is determined on the basis of the yield. Then necessarily applying suitable multiplier, the compensation needs to be awarded. Under no circumstances, the court should allow the compensation on the basis of the nature of the land as well as fruit bearing trees. In other words, market value of the land is determined twice over, once on the basis of the value of the land and again on the basis of the yield got from the fruit bearing trees. The definition of land includes the benefits which accrue from the land as defined in section 3A of the Act. After compensation is determined on the basis of the value of the land as distinct from the income applying suitable multiplier, then the trees would have to be valued only as firewood and necessary compensation would be given. We are afraid that the High Court has misread the said decision in regard to valuing the land and trees separately. If the land value had been determined with reference to the sales statistics or compensation awarded for the nearby vacant land, then necessarily the trees will have to be valued separately. But if the value of the land has been determined on the basis of the sales statistics or compensation awarded for an orchard, that is land with fruit bearing trees, then there is no question of again adding the value of the trees. This has been followed recently by the apex court.
Followed ಅಂದ್ರೆ ಇದ್ರಾಗ ಏನು ಹಂಗೆ ನೀವು ಹೇಳ್ದಂಗೆ ಇಲ್ಲ. You are reading it.
Sir, in your land is there, fruit bearing trees are there.
And also there are some structures. Sorry, ma'am.
Firewood trees are there and structure is there. All these should be included. All should be included, no? All should be included. If anything is left out, can land acquisition officer?
ಇದರಲ್ಲಿ ಏನು ಮಾಡಿದ್ರು, land acquisition officer took reports from all the subject experts. They gave values, but they are not included in the award.
Tomorrow, havoc it will be if that power is considered to pass additional award. Anything may happen. We are just contemplating the
Understood,
consequences of opposite of
But
your proposition.
this circumstance has also been considered in a writ petition by the learned single judge, and direction is issued to pass supplementary.
ಅದು ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ನಾಳೆ ವ್ಯವಹಾರ ನಡೀಲಿಕ್ಕೆ ಶುರು ಆಗ್ತದೆ. ನಾಳೆ tomorrow lot of ವ್ಯವಹಾರ starts.
Paragraph number 6. In this case also, it was noted in the award that there are trees, structures and other things, but value of them was not included in the award.
Come to 69.
Please.
64 is the reference.
Reference.
69 ನೋಡಿ ಏನೇನ್ ಡಿಸೈಡ್ ಮಾಡಬೇಕು ಅಂತ.
Determination of award by authority. In determining the amount of compensation to be awarded for the land acquired, including rehabilitation and resettlement entitlements, the authority shall take into consideration whether the collector has followed the parameters set out under section 26 to 30 or not.
ಅವನೊಂದು ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ 69 ಕೆಳಗಡೆ ಇಟ್ಸ್ ಎ ಗ್ರೌಂಡ್.
Not followed ಅಂದ್ರೆ 64 is the reference.
ಅದನ್ನ ರೆಫರೆನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ.
My humble submission is, but if it is considered and lesser value is awarded, reference can be made. If at all no award is passed.
No award is passed makes no difference because there is one award already. Whether in respect of other components, they were part of the award or not is the question. You are entitled to those things because obvious it is. Land immovable property is defined under the Transfer of Property Act section 3 and the General Clauses Act also. It includes what is fastened to earth, what is rooted into the earth, because trees and other things will be
things attached to the land.
Reference ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ನೀವು ಕ್ಲೇಮ್ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳಿ ಅದು ಇಲ್ಲೇ ಆರ್ಡರ್ ಮಾಡಿ ಕಳಿಸ್ಕೊಳ್ಳೋಣ. You have sent him without order on the ground that it cannot be done.
Lord, this ground was already urged in an earlier writ petition at page 144 may kindly be seen, wherein this honorable court has directed him to file a reference under section 64.
ಅದಕ್ಕೆ ಈಗ ಬಂದಿರ್ಲಿ.
ಅಲ್ಲ ಅಲ್ಲಿ 22 ನಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ on behalf of them that this will be taken care of in the award.
This has been
on that ground
in the year 2022 itself.
Now ಈ proposition ಒಪ್ಪಲ್ಲ. ಯಾಕಂದ್ರೆ it gives lot of scope for
at when 144.
ನಾಳೆ ಎಲ್ಲೇ would start making additional awards.
The same party petitioners approached this honorable court. Page 144.
Yes, we did. There a submission was made on behalf of the government advocate.
Section 14 apply ಆಗ್ತದ, reference 40 apply ಆಗ್ತದೆ. 14 apply ಆಗ್ತದೆ. So period spent in litigation. ಆ period minus ಮಾಡಿದ್ರೆ ಎಷ್ಟಾಗ್ತದೆ?
ಅಲ್ಲ 22 ಆರ್ಡರ್ ಆಗಿದೆ ಇದು 2 ವರ್ಷದ ಹಿಂದೆನೇ ಆಗಿದೆ. They have not filed reference. And again a fresh writ petition was filed before this court seeking the same relief, and the learned single judge passed an order. ಇಲ್ಲ, my lord, that was before award on the ground that it is not being considered. Then they made a submission that it will be considered in the award. Then award was passed, it was not considered. Therefore we filed another writ petition.
Therefore,
That
you should
cannot
file the reference.
No, I may agree to that position, my lord, as a statement, but
ಅದನ್ನ 14th ಯು
ಈಗ
ಲಿಮಿಟೇಷನ್ ಎಷ್ಟಿದೆ ರೆಫರೆನ್ಸಿಂಗ್?
90 days.
ಅಲ್ಲ, ಈ ಪೀರಿಯಡ್ ಅನ್ನು ಮೈನಸ್ ಮಾಡಿದ್ರೆ
I am afraid, my lord, we will still be out of limitation.
we are afraid that we may trample the limitation. By your persuasive advocacy, you may make us to jump the law.
Within 30 days from the date of
30
application.
days from the date of receipt of.
Application. Even application is not submitted. But in respect of other landowners, my lord, when similar relief is granted,
We cannot grant that.
and Supreme Court holds that, my lord, separate award has to be passed.
The short question of law that arises in the fact matrix of argued case of the appellant is whether an additional award can be passed by the LAO stroke SLAO, more particularly when the relevant components, namely components such as trees, etc., attached to the land have not been valued for the purpose of determination of compensation. First off, the net counsel for the appellant vehemently presses into service the provisions of section 29 of the 2013 Act. 39 and to contend for an affirmative answer to the question. First, learned HCGP appearing for the respondents make submission in justification of the impugned judgment of the learned single judge, specifically pointing out the earlier round of litigation and also the provisions of section 69 of the 2013 Act. First, next part. Having heard the counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the submission of learned government advocate HCGP, and also the reasons on which the impugned judgment is structured. First off, section 29 provides for what all to be taken note of while framing the award. First off, its text does not lend credence to the argument that it enables passing of additional award. First, the question of interpretation of this provision would not arise, its text being as clear as Gangetic waters and there being no scope for its construction. First, next paragraph. Learned the HCGP is right in telling the court that section 16, the scope of section 69, going by its wide text is enormous. First, where certain components which ought to have been taken cognizance of while determining the compensation and passing the award, and they are not taken into consideration, that is one of the texted circumstance in the section for seeking reference, which again is time bound. First, learned HCGP alerts us that the time for reference having expired, the appellants have chosen a circuitous route and therefore nothing can be done in the matter. First, we agree with this. Next one, in the circumstances, appeal being devoid of merits is liable to be rejected, and accordingly it is, costs having been made easy. Delay condone ಮಾಡ್ಕೊಂಡು.
I accept notice.
HCGP
At least more to approach, we'll try that to file a reference.
ಅದು ಬರುತ್ತೆ, ಟೈಮ್ ಬೌಂಡ್.
ಅಲ್ಲ, if that can be deducted,
ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದು. Next.
we may be reserved liberty more to approach the reference court.
ಅಲ್ಲಿ ಬರೋದು. Yes. That global, Dharwad, global considered section 74(1) proviso. The same principle applies to reference. Once period expires, no question of condonation of delay. Section 5 ಗೆ ಯಾವ apply ಆಗಲ್ಲ ಅಂತ ಬರ್ದಾರೆ. It applies that way. We did not say that because it was in a different context.
It has been upheld by the Lord's also, please.
It has been upheld by the apex court.
My lord, land of the petitioner was acquired. He was owner to the extent of 2 acres. My lord, 1 acre 11 guntas was acquired. 29 guntas, my lord, was remained unacquired. My lord, we requested for, my lord, demarcating the portion of the land which is not acquired. My lord, on the contrary, the acquiring authority has had issued notification as per Annexure J, invoking section 17.
Acquired land, unacquired land, demarcate ಮಾಡ್ರಿ ಅನ್ನದ.
Demarcate ಮಾಡಿ, my lord, hand over possession, my lord, demarcate ಮಾಡಿ ಕೊಡಿ ಅಂತ.
ಅವ್ರೇನ್ ಜಾಸ್ತಿ ತಗೊಂಡಾರ?
My lord, the entire portion is ತಗೊಂಡಿದ್ದಾರೆ.
Acquire ಮಾಡಿದ್ದೆಷ್ಟು?
My lord, pursuant to initially 1 acre odd was acquired. Thereafter, my lord, subsequently, which my lord, the appellant herein made a representation to either demarc or to acquire and to pay compensation. Pursuant to which, invoking section 17, my lord, we have initiated acquisition and award is passed. Now award is process of passing an award.
Extra land ತಗೊಂಡಿದ್ದಾರೆ.
ಹೌದು.
ಹಂಗಾಗಿ ಡಿಮಾರ್ಕೇಟ್ ಮಾಡೋ ಪ್ರಶ್ನೆ
ಪ್ರಶ್ನೆನೇ ಬರೋದಿಲ್ಲ. That was the request made.
My submission was, my lord, for acquisition, you could not invoke section 17.
No, you challenge, you have given consent. All those things will go.
My lord, my consent was for first demarcation. If it is not possible, acquire. My lord, if it is.
Your representation.
Yes.
Page 45.
Page 45.
Yes, please, Annexure C. From the bottom, his prayer starts.
ಪೂರ್ಣ ಜಮೀನನ್ನು ಸ್ವಾಧೀನ ಮಾಡಿಕೊಂಡು ಅಲ್ಲಿ ಪ್ಲಾಟ್ಗಳನ್ನು ಮಾಡಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ. ಈಗ ಉಳಿದ 29 ಗುಂಟೆ
ಎಲ್ಲದನ್ನು ಪ್ಲಾಟ್ ಮಾಡಿಬಿಟ್ಟಾರ ಅವ್ರು.
ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದಕ್ಕೆಲ್ಲ ಮತ್ತೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ತಾರೆ, ತಗೊಂಬಿಡಿ. ನೀವು ಒಪ್ಕೊಂಡ್ರಿ ಎಲ್ಲ ಯೂಸ್ ಮಾಡ್ಕೊಂಡಾರೆ ಅಂತ.
ಹೌದು. ಅದಕ್ಕೆ ಮಿಲಾಡ್ ಇನ್ವೋಕಿಂಗ್ ಸೆಕ್ಷನ್ 17 ವಿದೌಟ್ ಮಿಲಾಡ್ ಎನ್ಕ್ವೈರಿ, ಮಿಲಾಡ್ ಈಸ್ ಮೈ ಗ್ರೀವೆನ್ಸ್.
That was done only at the instance of his representation.
You only said that.
Yes.
ನೋಡಿ, ಪೂರ್ಣ ಜಮೀನನ್ನು ಸ್ವಾಧೀನ ಮಾಡಿಕೊಂಡು ಪ್ಲಾಟ್ಗಳನ್ನು ಮಾಡಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ. ನನಗೆ ಉಳಿದ ಜಮೀನು ಗುರುತಿಸಿ ನನಗೆ ತೋರಿಸಿ ಕೊಡಬೇಕು, ಅದರಂತೆ ಹದ್ದು ಗುರುತು ಮಾಡಬೇಕು. ಇದರ ಬಗ್ಗೆ ನಾನು ತಮಗೆ ಮುಖವಾಗಿ ಸಾಕಷ್ಟು ತಿಳಿಸಿದರೂ ಯಾವುದೇ ಪ್ರತಿಕ್ರಿಯೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಆದ ಕಾರಣ ಈಗ ನನ್ನ ಹೆಸರಿಗೆ ಇದ್ದ ಸದರಿ ಜಮೀನು ತೋರಿಸಿ ಹದ್ದು ಗುರುತು ಮಾಡಿ ಕೊಡಬೇಕು. ಇಲ್ಲದಿದ್ದರೆ ಆಲ್ಟರ್ನೇಟಿವ್ಲಿ ಸದರಿ ಕ್ಷೇತ್ರದ ಪರಿಹಾರ ಧನವನ್ನು ಪರಿಹಾರ ಧನ ಕೊಡ್ತಾರೆ.
Entire 29 guntas, milord, is not taken. Milord, I have produced a photograph showing that, milord, certain portion has remained with the appellant.
Just measurement ಏನದು?
Milord, that is precisely what they had to say, milord, as to
ಪೂರಾ ಲ್ಯಾಂಡ್ ತಗೊಳ್ರಿ ಅಂತ ನೀವು ಹೇಳಿರ ಆಲ್ರೆಡಿ.
ಯಾವುದು?
ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ದಲ್ಲಿ.
ಹೌದು.
ಪೂರಾ ಲ್ಯಾಂಡ್ ನಲ್ಲಿ ಮನೆ ಕಟ್ಟಿ ಆಗಿದೆ.
Milord, I have, milord, ಕಾಣಿಸುತ್ತದೆ.
ಕಾಣಿಸುತ್ತದೆ ಅಂದ್ರೆ ಏನದು? ಇದೆ ಅಂತ ಅರ್ಥ. ಕಾಣಿಸುತ್ತದೆ ಅಂದ್ರೆ
ಅಂದ್ರೆ ಮಿಲಾಡ್ portion, milord, he is residing there. Milord, in a portion.
These are all
or milord, may I make, milord, in view of the fact being, milord, possession being taken, milord, let them, milord, acquire the right under the provisions of the new act.
ಇದೆಲ್ಲ circuitous method.
ಇಲ್ಲ milord, that is what they say.
17 ಕೆಳಗೆ
Milord,
ಮಾಡಿದ್ದಾರೆ.
they have stated, milord, they have stated on oath that, milord, they will acquire and pass awards.
Till disposal.
Lord, so far as, my lord, this, my lord, there is a finding of the learned single judge that there is, my lord, corroborable exercise of power. My lord, absolutely.
That we are discussing that
Yes.
alone.
Because, my lord, notification doesn't, my lord, say as to why.
Colorable exercise. Colorable exercise of power concept illa.
My lord, my submission was, my lord, this notification was issued just, my lord, prior to the commencement of the 2013 Act.